call today's meeting of the Seclusion Working Group to order. Today is Wednesday, January 14th, and we do have a quorum. First order of business is approval of the previous meeting minutes. Hopefully everyone has had a chance to review the meeting minutes from our previous meeting. Could I have a motion to approve our prior meeting minutes? There's been a motion. Any discussion on the approval of the previous meeting minutes? Seeing none, all in favor of approving the minutes, say aye. Aye. Any opposed, say no. Motion passes and the minutes are approved. Okay. All right. The first thing I wanted to do here today, I know we have some draft recommendations for discussion, and I want to thank the people who got together and rolled up their sleeves and did the hard work of figuring out where we have consensus. So thank you all for your hard work. And I want to thank everyone who has been on this working group for engaging in these discussions on a topic that I know a lot of people feel really strongly about. And I think I shared this, but of all the issues have been exposed to here at the legislature, and I'm going to tell you there's a lot, this is the only one that has me really emotionally involved. So it's been really, really hard for me to set my feelings aside and not get emotionally reactionary. I probably have a few times before, and I apologize for that. But this one is a single issue, hands down, of everything I do here at the legislature that has me constantly keeping my emotions in check. So I appreciate everyone coming to the table here and engaging in productive discussions, because I really do think that was needed when it comes to this particular topic. What I wanted to do is start off today just talking about how we got here. As I mentioned, when we first convened in 2023, we banned seclusion from birth to grade 3 in Minnesota. And I did not know that we did that. I voted on the education omnibus bill that had that provision contained in it. I was not aware that that provision was in there. That's my fault for not reading it, but it's also a problem that we can take that kind of action as a state with legislators unaware of what we're doing. Once I learned that that had happened, and to be clear, had I known that that provision was in the education omnibus bill, I would have voted no on the education omnibus bill. Again, that's my fault for not reading it. These omnibus bills are large bills. End of session moves very, very quickly. And if anyone remembers 2023, we had a lot going on that particular session. Once I learned that this had been done, I took steps to try to allow seclusion where we had banned it. Because in my experience and in raising my son, who we heard from last time, who needed seclusion from time to time, I felt this was taking a tool away from school districts without providing anything in return to help with students who may be in emergency situations. So I started the process of talking, hey, why did we do this? Where did this come from? What is the concern? How can we fix this? What can we do? And was met with a lot of resistance because, as I've noted, this is a very emotional issue for a lot of people. And so at every turn, I was met with, no, we banned it, it's gonna stay banned. We're not interested in having any conversations. I got really frustrated because to me it felt harmful. So at the beginning of last session, I dropped a bill to repeal all the changes that we made in 2023 to the ban. And I did that mostly out of frustration because no one would engage a conversation with me about what can we do. Finally, when I dropped the bill, the conversations began. And what resulted, my original bill was to just repeal all the changes that we made in 2023 and put the law back to the way it was. Instead, through a lot of conversation with a lot of different stakeholders, we came up with the amendment that you have in front of you, which is 007-7. And this amendment passed the Senate. Senator Elise Mann was the proponent of the ban on seclusion from birth to grade 3 in 2023. She and I had a lot of discussions about this. I also had a lot of discussions with Senator Aaron McQuaid. And in the end, this met with their approval, 007-7. And what 007-7 does is this: it puts additional parameters around the use of seclusion through grade 6. So it extends the ban on seclusion up through grade 6 unless certain steps are followed. And what we've done is, so you can only use seclusion under 007-7 in grades 1 through 6 if the following are explicitly agreed to, if it is explicitly agreed to by all parents or guardians with legal decision-making authority regarding the child through informed written consent, which is separate from any other consent in the IEP process. And those of us who have been through the IEP process knows there is a ton of paperwork and a lot of confusing stuff to read and to sign. This is something totally set apart from that. That this consent be in the parents or guardian's primary language. In addition, on the very back of this page, the very last part, lines 6.26, 6.27, it also directs the Department of Education to develop and maintain oral translation of the notice for procedural safeguards. Because I heard concerns that there wasn't sufficient oral language translation. That written translation wasn't enough. Oral language translation was needed. So we added that as well to ensure that the parents or caregivers had in their native language, either writing or orally, the information contained in this consent. And as we know in the IEP world, a parent or a guardian is sent out a consent form. If they don't return it in 30 days, it's deemed consented to. That's not the case in my amendment when it came to seclusion. It had to come back signed, written, consented to explicitly by everybody. So a failure to return could not be considered consent. In addition to that, in addition to the existing statutory requirements, if a school used a seclusion room on a child on 2 separate days, school days within 20 calendar days, that automatically triggered a meeting, another IEP meeting, to discuss the effectiveness of the continued use of seclusion, other options for behavior interventions and supports, and would include showing the parents or guardians a room where the seclusion has occurred or may occur in the future. And actually, my idea was to move that piece to the initial consent so that there's no question in a parent's mind where the seclusion is going to take place, what it is they're talking about, and all this would be in their native language. It also directed the Commissioner of Education to provide outreach and education to parents and guardians of children who are subject to seclusion as to what seclusion is and is not, an explanation regarding the appropriate uses of seclusion, what constitutes an emergency for purposes of using seclusion, and information regarding legal safeguards surrounding the use of seclusion. And I am and always have been willing to include additional resources and safeguards. For example, we spoke of making it easier so the onus doesn't fall on parents to report, or some easier way to report misuses. That has always been something I've been willing to agree to. The amendment goes on to state a data reporting requirement. Each individual in grades 1 through 6 who have been secluded, a summary report of the use of seclusion in which the school using seclusion is located, the number of seclusion rooms used, where the rooms are located, the grade and federal setting level of the students, how many students, how many times it was used, demographics of students, and known positive behavioral intervention used within the school. The idea being to gather additional data on when, how often, and with whom seclusion was being used. That being said, I really like what the working group has come up with in terms of data gathering. I think that's much better. Finally, at the end of the amendment here, lines 6.4 through 6.24, this is the part that I know that there is some opposition to, because what it does is, it includes the use of seclusion on children from grade 1 through grade 6, unless the seclusion is explicitly agreed to as provided in the sections I just talked about. The remaining part of this language I think is important, and I think we as a work group should consider this. If we look down, and some of this language is included in some of the proposed recommendations. So for example, line 6.9 forward, IEP meeting to discuss the use of seclusion must include the child's treating mental health professional or a school district mental health professional, licensed school nurse or registered nurse. All of this so that potential contraindications can be identified. I like the language that's contained in the recommendations when it comes to that, and I like how as I read the recommendations, it applies to IEPs in general, not just the ones talking about seclusion. But I do think it's relevant when it comes to seclusion and other restrictive procedures. Starting at 6.14, oh, here it is, yeah, here it is. A parent or guardian must be shown the seclusion room before providing explicit written consent for the use of seclusion. I think that's important. I think a lot of what I heard was a misunderstanding or an inability to comprehend, not just with parents and guardians who are not native English speakers, but by some parents and guardians. When acronyms start getting thrown around and terminology starts getting used that maybe is not familiar to a parent or guardian, and particularly an IEP process can be an overwhelming process. I think actually getting up from the table and walking down the hall and seeing the seclusion room is useful and will help reset the conversation. So my proposal and what was passed by the Senate was that before a parent or guardian is asked to consent to the use of seclusion in an IEP, they actually walk down the hall and they see that room. And what I would wager is that will open up an opportunity to ask questions, and that will help fill in some of the gaps in what can be a really overwhelming process. Finally, if we look in lines 6.15 through 6.18, in cases of administrative dispute or other judicial or quasi-judicial dispute or proceeding, an administrative law judge, mediator, arbitrator, judge, or other presiding official is prohibited from ordering the use of seclusion over the objection of a child's parent or guardian. Again, I think this is important too to safeguard the rights of parents and children. What we don't want is to have parents go through this whole process explicitly not consent to seclusion. The team agrees, everybody's good, but somewhere down the line, an ALJ or a judge or a mediator or somebody comes in and overrides that decision. That's not what anybody wants. So with conversations with other stakeholders, we came up with this language. So I have read the objection. The way I read the objection is to any rollback of the ban that we currently have on grades kindergarten, well, birth through 3, grade 3. And so with respect to the amendment 007-7, which would expand the ban through grade 6, leave it as it is for kindergarten and lower, younger, but incorporate these additional procedural safeguards in to grades 1, 2, and 3. With respect to grades 1, 2, and 3, I understand the objection is no changes, leave it as a ban. But what I would like us to do as a work group, once we're done talking about the areas that we agree to, is start to consider some of these other provisions and maybe discuss whether there's a place for that as well. So, that's where we are. That was a really long-winded way of sort of mapping out how we came to have 007-7. So let's put a pin in that for right now. Let's turn to the draft recommendations for discussion. First, I'd like to ask if there's anybody who has not had an opportunity to go through the draft recommendations for discussion. Okay. I'd also like to pause and recognize for a moment, Senator Julia Coleman is going through a loss in her family. She is present virtually, but I think her mind is engaged in other more important things. So out of respect for her time, I'd like to move forward through voting as soon as we can so that we can allow her to log off and be with her family, because nobody wants to be at a wake and attending a work group at the same time. So if I feel like I'm rushing things, I am, because I want to give her her time back. And I appreciate her logging in during this incredibly difficult time for her family. So going through the draft recommendations for discussion, I only have a couple of comments. In looking under the first section, number 1 and number 2, after the word mandate, I would propose adding the words "and fund." Because we all know how much discussion there has been around unfunded mandates in the world of education. So I don't want to get caught engaging in that cycle of discussion again. So I would suggest adding the words "and fund" after the word mandate. Can we just? Does anybody oppose that? Is there anyone who has an idea that that's maybe not what we want to do? Okay, I would ask Mr. George to insert that language in the proposed draft recommendations for discussion. Under mandatory staff training, staff supports and culture shift, number 1, the second line where it says level 3 and level 4 settings, I am wondering this, would it be better to say level 3 and higher? And the only reason I say that is I don't want to hamstring our setting 4, setting 5, setting 6, setting 7, or hospital-based programs. Does anybody have any thoughts on that? Ms. Heiser.
Thank you. Thank you, Madam Chair. My only concern is, some of those settings are homebound settings. Are we going to require parents to undergo the training as well? That's why the working group discussed level 3 and level 4, since the vast majority of seclusion occurs in those settings.
And that's a great question. No, but a setting 8 does include some hospital settings. So, and we do know that seclusion occurs in hospitals and seclusion does occur in residential facilities. And what I don't want to have happen is we draft a law and unintendedly now, if a youth is in United Hospital, for example, and they're there, let's just use an example from my own life. They're being boarded for 9 days because there's no beds, and the hospital offers to provide school, that now all of a sudden, for some reason, the student can't get education training or school training because schools or teachers or staff don't want to run afoul of our law. So my son was technically in seclusion for 9 days in the locked unit of United Hospital waiting for a bed. So that's my concern. I don't want to hamstring hospitals, institutional, residential programs, or those, but certainly the idea is not to require homebound caregivers to do all of this. Any thoughts? Yes. Ms. Hulse.
I don't think I have the language, and I think, Greta, I'm looking at you as well. But typically, in those types of situations, the educators are actually not allowed to participate in any decisions around seclusion in those care and treatment style settings. You're typically relinquishing actually all of that decision-making authority to the DHS licensed authorities, so to the hospital, to the treatment staff, or to the corrections staff. And so I wonder if we could arrive at wording around some sort of training, but that doesn't perhaps mandate the same thing necessarily as for 3 and 4, because I think that the knowledge is important, but it's not the same. Those staff don't have the same level of decision-making authority in those situations. I hope that's clear.
It does. That helps me kind of understand. I guess with that said, I'm comfortable then leaving it as level 3 and level 4 because we're really talking about like schools. Yeah. And when we start moving out of in 5 and higher, we're not in a school setting anymore. We're in a medical or a correctional setting. Yeah. Okay. I think I feel better. Okay. Any other? Yeah, Ms. Yeah, sorry.
No, yeah, I just wanted to add, I think, thinking about scope, you know, we've talked a lot about like what are the things that this work group is focused on. I think focusing on school specific, because that's a whole other broad discussion to bring in hospital settings and yeah, to bring in everything that was mentioned. So I just want to put that 2 cents in. Thank you.
Okay, I feel better leaving it then, level 3 and 4. My only other suggestion with regard to language is on the second page, paragraph number 3. For students with an IEP who are subjected to seclusion, I don't like the word subjected. I know some do. I would rather find some more neutral language. So perhaps for students with an IEP which includes seclusion, or for students who have an IEP and upon whom seclusion is used, something like that. Do we have any thoughts or comments on that proposed change?
Madam Chair, I wonder if it could be changed to just for a one word for students with an IEP who have experienced seclusion or experience. I think that's part of the thought, but I'm open to other suggestions, but I understand the intent of the question. But what about, how do we feel about the word experience?
Ms. Woodward.
I think the goal here is that, you know, again, to some of the concerns brought forward about inappropriate use of seclusion, someone could experience seclusion and it not be in their IEP. And the intent of the language here is, what does that requirement look like when it's included in the IEP? So my recommendation would be for students whose IEP includes the use of seclusion.
Ms. Heiser's not there yet. Ms. Sandsmark.
Well, I'm going to let Ms. Heiser speak for herself when thinking through maybe the counterpoint to this. But in my thoughts, I wonder, you know, if seclusion in law is an emergency procedure, and I assume, or if it's happening outside of individuals that don't have it in their IEP because there's an emergency situation and something occurs. I assume that, you know, that of course happens. I think the intent was maybe not to over limit, if that makes sense. I'm not sure, actually, so I'm gonna stop talking, but that's just a thought.
Okay, I hear you. Ms. Woodward.
Ms. Sandsmark, I wonder, thank you, Chair. I think perhaps the concern that you're getting at is if seclusion is used for a student with an IEP and that it's not currently in their IEP, and I see Jessica there. So I'm curious, I think one item can only address so much, and I think, again, the intent of number 3 is that when it's included, like, what are the requirements for reviewing that data, but perhaps that concern warrants an additional item so that if it's used in an emergency situation for a student with an IEP, like, what does that trigger? Like, there might be something additional there where if a I'm just but if seclusion is used for a student with an IEP and it is not already noted in their IEP, the IEP team must meet to consider the use and talk about blah, blah, blah. That's not a very formal word, blah, 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 but you know what I'm saying. So I think it might warrant an additional item.
Ms. Heiser.
Thank you, Madam Chair. This is very similar to how we felt while we were all in our small group together, throwing ideas out. And then, I'd kind of look over and be like, yeah, that's it, Nicole, good. So no, I agree with Ms. Woodward's suggestion here. I'm comfortable if we want to revise number 3 to only include those students who do have seclusion as part of their IEP already, while adding a 4th recommendation that for a student with disabilities who experiences seclusion and it is not indicated in their IEP, then obviously we need to get the team together and discuss what's going on there, maybe a new FBA or something to that effect. So I am in agreement with the suggestion that these are 2 separate concerns that the group is dancing around here. One is for students who do already have seclusion within their IEP, and one is for students who do not.
Will our small idea and language smithing group agree to draft and or revise paragraphs 3 and 4 between now and, okay, you guys are the best, thank you. And when it comes to the IEP, IFSP requirements, 1, 2, 3, the new 4, I did notice some alignment with the amendment 007-7. So I'm hoping that we can, it looks like it was a starting place. You guys kind of honed it in and made it better. And I think I want to congratulate you for working so hard and doing such a good job on this. Ms. Woodward.
Thank you, Senator Seeberger. I want to make a comment because I think it's important to understand how this may fit within existing context. But currently, if restrictive procedures are used twice in a 30-day period, the IEP, no matter if that's in their IEP or not, the IEP team has to meet. So that is an existing practice already in 125A.942. Did I say that right, or 492? 49942, I nailed it, okay. But so we would just need to consider if that needs to look different for seclusion, is that one use, but that currently exists within the statute is twice within that 30-day period.
I would also invite folks to review the language in 007-7. I think it speaks to, it would be lines 2.3 through 2.13, which adds some, if a school uses seclusion on 2 separate school days within 20 calendar days, then it triggers an IEP meeting, and then some of the other criteria. So if there's anything in there you could incorporate, or which might make it even better, I would encourage you folks to take a look at that. And those are all the suggestions I have with regard to this document. Is there any other discussion with regard to the draft recommendations for discussion as amended or edited? Ms. Heiser.
Thank you, Madam Chair. There was one piece that we had not fully worked out with a small group of 4 of us. It's on the last page of the packet. And I just had a question to pose to the school district representatives. We had originally had some language around the mandated adoption of an alternative to seclusion program. And then there was some suggestion that that mandate would only be required if it was paired with funding for implementation. And that goes back to one of our original concerns about unfunded mandates, of course. My question was, my understanding is that most districts already have adopted some sort of alternative to seclusion. I mean, we talked at length here about Ukuru, but there's, a long list. But this would be a question around the alternative programs that MDE has kind of signed off and said, we bless these. So how much of a burden would it be on school districts to have this mandate without the funding attached to it? Are you already there anyway, for the most part?
Mr. Haveman.
I'm going to take a stab at this. The answer is I don't know in terms of how that would be received by the various types of school districts, because you're right, there are quite a few school districts, maybe more so in the metro, that have started to take on a program like UCARU, like we did last year, and we're continuing to do this year. However, outstate might be a completely different story. Charter schools might be a completely different story. As far as the financial onus that they would have to start this up, some of these are quite expensive. UCARU is expensive to get off the ground. So I would hesitate to not have some funding that goes along with that, because I think it's going to be pretty burdensome for them to take on without that.
I will add, in addition to not creating any unfunded mandates in the education system, and I hear what you're saying, what I'm hearing is there's a concern that if the money doesn't go, it will preclude the implementation of some of these. But I think as a legislature, we prioritize things by giving them money. And this is a priority. And there's a lot of different ideas floating around in the interim of where we can spend money when it comes to schools. The only one I'm going to agree to and champion is this one here, where we give money to help our special ed students, and particularly those who may be subject to restricted procedures. So that's my thought. I am hesitant to send any recommendation to the legislature that does not that does not obligate them to fund it. But I do understand the pitfall of that. Anyway, Ms. Woodward.
I don't know how much this directly answers your question, Ms. Heiser, but I do think it's important to note. I think when it comes to some of what we've talked about in this work group around concerns with misuse or overuse, things like that these alternatives to seclusion would address, there's a difference from my perspective on implementing a new program or practice and corrective action continuous improvement. And there are times when a district can take a practice that they have in place and intensify it, or get, enhance fidelity of implementation. Like, there could be a lot of reasons why the outcomes aren't as we desire. So like for my district, for example, or my districts, we've used CPI, that's our restrictive procedures. It includes verbal de-escalation and all things that you would assume would reduce the need for seclusion. We weren't necessarily getting the outcomes in some of the places that we wanted, including high injury and things like that, which is why we invested money to adopt a new program like UCARU. So when it comes to, when you ask, like, aren't you doing some of these things? Aren't they already there? Like, many districts do have programs in place to mitigate the need. How effective they are, or what threshold we would be at before we would say you need to implement something else or one of these other programs. Like, that's that line where, is it corrective action and continuous improvement, or is it implementation of a new evidence-based practice? And so I'm just noting that kind of line and how we look at that, and both can have space as we talk about this conversation, which is kind of where that ARC report would come in response to that and potential corrective action. But when we're saying you must adopt this new thing, that's where we really need to make sure that there's money available for that.
Ms. Baker.
Thank you. I also wanted to just speak to the cost of what this does for districts. Yes, we all have strategies that we use, but it's not just training staff and then you're done. We have to continually train staff over years to keep up their certification. Another thing that we run into that is a barrier is that when we have staff turnover, we have to go and when we hire new staff, retrain people all over again. To help reduce the cost of bringing in trainers, a lot of times we'll spend additional funds to have trainers within our district, which again is an additional expense for district. The mats for Ukiru are great, but honestly, like they're very expensive. And to make it where it works if you have multiple setting threes within your district, it's best to purchase a set of mats for every room, which again is expensive. And then if you have a student that's really rough on some of the mats, sometimes you have to replace them. So again, that is an additional expense. It's just not a one and done fee. It's a recurring expense that happens every school year.
Ms. Heiser.
I'm going to float an idea that I think is actually Nicole's idea, so let me give due credit here. What if we take the last paragraph on the, so number 2, where it says school districts have to adopt one of these alternative programs that MDE has blessed, right? What if we move that under data collection, monitoring, and accountability, number 2, where this goes into Ms. Woodward's point here. I'm so sorry. Is it Dr. Woodward? Okay, all right. That might have been a sensitive question. I just didn't, I wanted to make sure I didn't misstate that. I'm so sorry, Nicole. Okay, all right. The future Dr. Woodward says here where we have this language that we all kind of agreed on around the outer accountability. So if a district is not meeting the decrease of use or it's consistently above some certain threshold, that there is some sort of corrective action plan and that MDE does step in with allocating additional resources. Would it make more sense to put adopting programs up in that section and taking it out of the alternative to seclusion section and essentially tying that together so the funding is there and there is a demonstrated need for a new program?
We're thinking. Sounds like there's consensus to doing that. So moving on the final page of the draft recommendations for discussion, moving the paragraph number 2 to discuss as a group, that concept or language into paragraph number 2 under data collection, monitoring, and accountability. Ms. Sandsmark.
I'm also in agreement, and I'm just wondering, that paragraph itself, school districts must, we could, adjust the language to say school districts that, to combine that, school districts that aren't meeting the threshold or, just to adjust that language so it perfectly ties in. That's my suggestion.
Sounds like there's consensus. All right, so our small group then can make that wordsmithing and good, okay. Any other discussion on the draft recommendations? All right, I think we're ready for a motion then. And I was just conferring with Mr. George on how best to do this, since we have consensus on a few things that haven't necessarily been drafted yet, but I think we can move forward on the idea and have the language ready to go for the next meeting, unless anyone feels differently or has an idea for a different plan. Ms. Sandsmark.
Thank you, Madam Chair. Just, as we were looking through the draft recommendations, I think the language around disproportionality isn't really being brought in. I'm just wondering, it's okay if it's not included in this specific portion, but I wonder if that can be added or looked at in the training, or just making sure some of that language is brought in to recommendations. And I'm not sure it does it. Oh. Like doing it in the threshold area around the MDE expectations. Does that make sense? And number 2, data collection, monitoring, and accountability, making sure disproportionality based on race, whatever we need to determine that as to be included, just so it's not lost in the shuffle. Yeah.
Any thoughts? Ms. Woodward?
Thank you, Senator Seeberger. We had talked about that, and I think we had some broad consensus about including that within the framework that exists in notifying districts of disproportionality in their discipline data and other indicators. What I don't know, and I think that it would be good to get feedback from the department, is when it comes to that disproportionality, those calculations. So when I'm notified if there's a disproportionality with suspension or identification of a certain disability or programming for students in a certain federal setting, I don't know how they determine which thresholds they're looking at, and if that's mandated federally. We often in Minnesota exceed that on our own anyway, so I don't think there would be a barrier to MDE adding that as an indicator that they use in their disproportionality calculation and notification, and we don't see any concerns with that. So that I would look to the department for that, but I think that would be a reasonable recommendation to include.
Ms. Sandsmark?
I was just going to say thank you, Ms. Woodward, to that. And I think as we come back and maybe look at that language in our little small group, that looking at adding it into number 2 just as another line item of like, this is something that we are paying attention to and making sure that we want to hold accountable. I think that's important. So I appreciate the conversation.
All right. All right. So I think we're ready to vote. Senator Coleman, we're going to be voting. I propose a motion as follows: that we move to adopt the draft recommendations for discussion that we all have and that we've been talking about, and to instruct staff to make technical edits as agreed upon in today's meeting, which edits will include the language that our small group has agreed to draft as it relates to the paragraph 3 and new paragraph 4 on page 2, moving the paragraph from the last page to the MDE-based data accountability section, and language on proportionality. And the motion is that we approve that as final recommendations to go into the report. That's the motion. Who would like to make it? There we go. Ms. Woodward did it. All right. Any discussion on the motion? Seeing none, all in favor say aye. Aye.
Aye.
All right. Any opposed say no. All right, motion carries, and the draft recommendations are approved pending technical edits. Wonderful. All right. Great work, everybody. Thank you. Thank you. Let's see. Now, where are we? I was sort of wondering how we were going to land this plane. We did a really nice job, I think, with these draft recommendations. Here's what I'm thinking. There's still, I think, a few outstanding areas where we may not have agreement. I'm glad that we do have agreement. Here's my question. I would like, the next scheduled meeting is in 2 weeks, and what I envision to occur on that day is to have a draft final report that we all review and approve. I don't anticipate a whole lot of discussion. I'm going to let Senator Coleman off the hook here in about 20 minutes so she can go be with her family. Do we want to begin discussion on some of the areas that we don't have consensus and see if we can make any progress? Do we want to schedule another meeting for next week? How do we want to move forward? Nobody knows. Oh, Ms. Woodward. Dr. Woodward.
Thank you, Dr. Woodward, on the mic. Just kidding. I guess I would think that it would be great if we could at least start to unpack those conversations and use the time that we have available to start to discuss and get things on the table. That may lead us to decide, toward the end of the meeting that we want to schedule an additional meeting, but I think it would be really great if we could start.
Yes, I see heads nodding, yes. Okay. All right. Let's begin identifying those areas where we do not have consensus and perhaps figure out where we maybe want to go from there. As it relates to, I think we've done a great job with the training, culture shift, IEP, and we've I think, fleshed out the process very well. We're still stuck with the K through 3 ban. So we still have districts who feel hamstrung, folks who are not in as good of a position as they could be to help their students who are in an emergency situation. Again, I would propose additional safeguards built in as we see them in 007-7. I have read the opposition, and it's included in our packet, of Solutions Not Suspensions and other groups opposing any rolling back of the ban. I don't know if that's where we start, but that's an issue that I see that is unresolved, if anybody else wants to tee anything else up. Mr. Haveman.
Yes, I guess, thank you, Senator Seeberger. I guess to piggyback off that, because you introduced 007-7 at the beginning of this, I'd be curious to hear maybe from those opposed to repealing this, with the way that you've laid this out, with the provisions in place, like what would be the opposition and some rationale behind that. I would just want to hear from that side.
Absolutely. Thank you, Madam Chair. So, including Amendment AML 007-7 to the work of and to be talked about and discussed makes complete sense as it was introduced to the Senate in the spring, and bringing that language here in the work group. Community members have reached out to the Solutions Not Suspensions Coalition in fear of us recommending this amendment. This open letter is purely and truly about keeping place the current birth through 3 ban. That the fear is that the amendment brought forward would undermine the current ban, yes, including bringing this into the IEP process and expanding it in that way gives a lot of our colleagues, community members pause, and is something that people are interested in not rolling back and not wanting to repeal that portion of current legislation. So over the past 2 days after that was put on the public Seclusion Work Group resources, this number of people has reached out and put their name either through organizations or as individuals to oppose the inclusion or voting through or recommending this amendment as it is here. Not every part of the amendment is bad. I like to see oral translations and things that make the IEP process better for better for parents, better for students, and making sure seclusion is a really clear line item. However, at the basis of all this, we do not want to see our youngest learners for seclusion to be utilized on the youngest population, and we don't want to see that rolled back. So out in space, that's where we're at.
And before I let you speak, Ms. Woodward, and those are the concerns that we've all heard. And those are the concerns that I tried to address in drafting 007-7. Certainly it puts agency in the hands of the parents and caregivers. No caregiver has to consent to it. If one caregiver says yes and the other says no, it's a no. If there's not explicit consent, if there are additional ways to build in safeguards, I am open to that discussion. I circle back, and I'm certainly not, I validate all the experiences of the parents that you've heard from, but I need validation as a parent as well, that my student needed seclusion. You heard from him, you saw him. He's a big guy. He's a big guy now. He's 20. He looks not 20. But he's always looked older, and he's always been really, really big. And I'll say it again, in second grade, he broke a pair of his thumb because that was his reaction. What he needed was to break the cycle, the interactive cycle of being in the presence of an adult. And what that was being put in a room by himself. I knew it was happening. Every time it happened, I was called. But in his case, it was useful. And you'd heard him say, yeah, it sucked, but it needed to be done. Because in his mind, he was trying to prove a point. He and I have talked about it, but he was trying to prove a point. And as long as he was with the adult, that conversation was still happening. And the conversation consisted of kicking, hitting, spitting, biting, wrestling. And he needed that time away. So, is there a middle ground to protect parents like me and our students, our youngest learners, who are 2, in second grade, I mean 2, grade 2, right? Grade 1. He would put himself in seclusion in kindergarten. He would make a little fort and crawl under a desk. Okay? It's not statutorily defined seclusion. It wasn't in a result of an emergency, but he was having a crisis, and that's what he needed, was time away. So is there a middle ground that honors my experience as a parent, my son's experience as a student, the school's experience who are doing their darndest to do it right according to the statute, and to acknowledge that there are students who need it? There's a place for it for some students. We heard from a parent who said her son, there was a place for it for him. I don't think we can paint with such a broad brush. I would like us to find a way that honors everyone's experience as a student and supports them in the best way that we can in their education journey. Ms. Woodward.
Thank you. I understand the comfort that comes with a ban. right? Like, I really understand that. Like, whew, okay, like, I get that, particularly for parents who find the educational system complex and challenging to navigate. So I think my question is, what are the solution? We kind of had some conversations around this earlier on, because there are complexities. There are things like translation and all of the paperwork and all of the jargon, and we understand that and are continually working with our staff to try to make that more parent-friendly, more accessible. So I think, what are some of the ways that we could address those, what's at the heart of the concern? Is it that I don't feel empowered to make the decision and provide the consent? You know, is it that they don't understand what we're truly talking about? Is it the like, I'm really trying to understand what's at the heart, to Senator Seeberger's point, to create space for those different approaches and different perspectives across the board. So again, I get the comfort, I really do. Is there something specific with parent rights or parent advocacy or education or the consent that we could be doing that would help bridge that?
Ms. Heiser?
Thank you, Madam Chair. We okay? Sorry, we had a disruption in the room for those of you who are watching online. I appreciate the future Dr. Woodward's question. There are good things in this amendment. There are good things in this amendment and in the recommendations that do provide additional supports for parents who are going through a very confusing time, and who need to make an informed decision about their child. There are some good things in here. I'm a little concerned that it stops at grade 6. I'd be happy with it going up through grade 12. But there are certain practices that are too dangerous to have in our educational systems. We used to strike children with rulers and spank children in our schools. We don't do that anymore. There are 11 states in this country in the last couple of years who have outright banned seclusion regardless of any consent of a student or parent, and simply said it's too dangerous to have in our schools. So while I appreciate a lot of the extra protections that have been included in this amendment and in our draft recommendations that we all just voted on together, the idea that we are going to take a step backwards as a state and now allow any use of seclusion in K through 3 where we have, in grades 1 through 3, where we have effectively taken a minor first step forward to this overall goal. We've all agreed we don't want to use seclusion as a state. In the long run, we don't want to do this. We disagree on the timeline, but there has been no disagreement around it's disproportionately used against Black and brown kids. It's disproportionately used against boys with certain disabilities. We don't want to be doing this. So there's a piece there of we've taken a step forward, and to take a step backwards by reallowing it in this time of a year and a half where we've seen 40% drops in seclusion, that is something that I don't see how we're going to see eye to eye on. I think the additional recommendations, the additional supports, let's take them through 4th through 12th grade. They're great. And they do give parents more ability to understand what they're consenting to. But the idea that we're going to take a step backwards at all in the minor step we've taken forward is not something that I think we're ever going to see eye to eye on.
Before I allow you an opportunity to comment, I disagree that it would be taking a step backward. A ban on anything is a blanket reaction to something rather than a refinement of identifying what the problem is and how we can fix it. You say certain practices are too dangerous to have in our educational system. In my family's experience, it's too dangerous not to have the ability to have seclusion for my son. When you talk about reduction in the use of seclusion, the same data shows an increase in the use of restrictive procedures and staff and student injury. I don't think that's a good outcome or a good result. I don't think that putting staff at risk for injury, student at risk for injury, and further emotional trauma by having them pinned down by adults is better than giving them a space to calm down. That's where I take issue with your perspective, because I think it ignores the harm that we're doing to students who would otherwise benefit from seclusion. I think this is the time, I get it. We don't want seclusion, but I think we have to move forward past that premise and recognize when we have a student who's having an emergency, is it better to pin them down and inflict more emotional trauma on this child or not? I would rather leave the option on the table and give the parents and the family and the caregivers the agency to make that decision using all the tools that we built in here in 007-7, than stick with the ban. And finally, I have to reiterate myself, had I known it was in that education omnibus, I would have been a no. There was no reasoned debate among the legislature on this provision. There was no caucusing within my own caucus on this. There was no general consensus as a legislature that this is what we wanted to do. There was some discussion in a committee. It was an amendment that was added during the committee process. But beyond that, there was no, I will not say that there was legislative consensus to doing this. There was trickery. There was fast-moving amendments that were not fully brought to light. And that's how it was enacted, not through thoughtful discussion by the legislature. So I would argue this does not reflect the will of the legislature. This does not reflect the informed discussion of the legislature. This is something that was slipped in and evaded notice by a lot of different people. I will also point out that, like I said before, the author of the amendment of the seclusion ban, she gave me her blessing to 0077. I again ask, is there a way we can acknowledge nobody wants to use seclusion? Nobody wants to see it used on our youngest learners. There is an interest in everyone to move past that and at the same time acknowledge we're not there yet. We need to bridge the gap here and allow students and families to be able to utilize the tools that are best to them through thoughtful conversation and full disclosure and discourse and viewing of the room and the setting before making a pronouncement that my students, my son's experience doesn't matter, that you know better than what I do as a mother or his care team or his case manager because someone else had a bad experience with seclusion. Because to me, that's offensive. That's disregarding my experience, my son's experience. You heard it out of his own mouth of what was important to him and what he needed. Ms. Woodward.
Thank you, Chair Seeberger. You've said a lot of what I was going to say. I think at the heart that, it's too dangerous in our schools. And I think that perspective on what is dangerous and for whom, that's where we're bringing very different perspectives. Of course we are. That's literally the lens you use day to day in your role as an advocate. So I understand that. But I also look at some of the data that we've reviewed where, since 22-23, our staff injuries have almost doubled. and the amount of restrictive procedures continues to rise at a significant rate. And that is because we are experiencing more emergency procedures and the need for emergency situations than we did in the past. The landscape has changed. The level of aggression coming through the doors of our schools is substantially higher. And I think that's where we're trying to come to the table. You know, these recommendations in the amendment do substantially increase procedural safeguards. They do substantially limit the appropriate use of seclusion. You know, the percentage of students being served in settings 3 and 4 is vastly different, vastly smaller than the broad student population for whom the restrictive procedures statute applies. So I think, and completely open, I think, and it's actually often better to have consistent practices K-12 than here's what you do for K-6 versus in 7th grade it magically changes and you don't need explicit consent. I think a lot of the reason that the recommendations are written K-6 or grade 1 through 6 is because of the ban. But I would have no, and I'm looking to my school colleagues, I would have no concern saying, yeah, this is what it is for seclusion specifically through grade 12. So I think perhaps the question that we have to answer when we go back, that I don't know that you have to, that perhaps we could have some discussion on, is what else are we to do in those extremely emergent situations that staff are facing during the school day? What is the alternative solution to remove danger to the best of our ability from our schools for staff and students alike? Because we have to answer that question for both students and staff. And that's what we're trying to do with this. It is more work. It is more things to do and report and consider and restrict and train. And we're willing to take on that responsibility. We have to answer that other question. And I think that that's at the heart of the disagreement. And I'm really trying to find an opportunity for us to explore that. So that is the comment that I had. And just any immediate thoughts you have on that, what is the alternative?
Is it Moles?
Yes. Hi, thank you, Madam Chair. My name is Fatima, and I help a lot of families. I'm also a mother of a severely autistic son, okay, boy. The stories I hear from the families I support, there was, first of all, it impacts 90% of black kids, okay, black boys. This mother shared with me that her son was put in seclusion room every single day, and she didn't even know. She was never notified. The school did not notify nor call her. The only way she found out was a day that she just passed the door, and one of the staff told her, oh yeah, your son is in that room. The room was locked. A janitorial room, he was locked in that room, and there was a little window, and someone was blocking him. The door was locked. That's how we learned that this child was in a seclusion room for like pretty much, they said, well, every day since he enrolled, school started. Seclusion causes trauma. You know, my son has some behavior. I know that some days, you know, are hard, but some, you know, they don't let us know. The schools don't call the parents that speak language, speak other language than English. And I know that it impacts in my community a lot. So, you know, maybe we can come up with a better plan, ideas. But, you know, if a kid is having a behavior, they can't get a hold of a family, they immediately put it in a locked room. That's not right. The child needs interaction. The child needs to see human. My son is nonverbal. I know he tells me when he's hurt. The same thing happened to that kid. They're friends, the boys are friends. And he was traumatized and would not go back to school. So we have to really think about this. It does cause trauma for the families and the kids. Thank you.
And thank you for sharing that, Ms. Moles. And none of that was okay. That's not That's not okay under any circumstances. And I fully acknowledge and agree that seclusion does harm some students. And for those students, it's not appropriate and should never be used. And that's what we're trying to figure out here today, is how do we do the best for all our kids? Nobody here wants to use seclusion on a student that will cause further trauma to that student. No one on this work group thinks that locking a student in a janitorial closet is okay. That's not okay. No one thinks that using seclusion as discipline is okay. That's against the law. And I want to acknowledge that none of that is okay. And I hope your son and your son's friends is recovering from that. These are the things we want to avoid. And at the same time, students who are physically restrained suffer the same kind of trauma. So without adding to the trauma, without encouraging, and I will say this, even with the seclusion ban in place, seclusion is still being used. So a ban doesn't fix it. But what we're trying to do is build in things into the system to address the misuse, to protect our kids from further trauma, to protect our staff from further injury. And so I'm not saying every student should have seclusion. I'm not minimizing the experience of your son or your son's friend. Those are awful. Those are terrible experiences that should have never happened. So how do we protect those students and protect the students that do benefit from seclusion? That's the question. How can we identify the issue? I think Ms. Woodward put it really well. How do we get there? I understand the philosophical opposition to any use of seclusion, but I simply can't ignore the increase in injuries and restrictive procedures that we're seeing. How do we bridge that gap? Ms. Winship.
Thank you, Madam Chair. You know, when we went and did that visit and saw the seclusion room, that confirmed for me that I don't like seclusion. I don't see the benefit of seclusion. And I also understand, you know, we heard from folks that it was helpful. I think the addition of that explicit consent from parents, having to see the seclusion room, having to agree to it, me having that opportunity to tell the school, no, I do not want my little guy going into seclusion, it helps me a little bit. I think, again, and if we did, I would absolutely want it to be K-12. I agree with that. Ultimately, I would love to keep the K-3 ban. And I appreciate those additional kind of things that would leave it to the parents to decide yay or nay when it comes to their child.
Thank you. Parents and mental health professionals and what else did I put in here? A cadre of folks to identify, and the rationale is to identify students for whom there would be more trauma. We don't want that. We want the professionals to step in and say, as this child's caseworker, as this child's psychologist, or this child's behavioral specialist, or this child's mental health specialist, in my professional opinion, or even my gut feeling is, seclusion would be harmful. And that person has a voice at the table. Ms. Heiser.
I've been on the whole time. I've been on a hot mic the whole time. Well, that's scary. Thank you, Madam Chair. I think one of the things that could be part of this discussion is if this amendment was to be adopted as a recommendation for this group, I'm looking for compromise, I really am. We've all agreed, taking it up to 12th grade would make sense. But what also bothers me is that we lose any sort of timetable, that this is just out there as long as it can possibly be out there. And we've all discussed the need to move towards a elimination of seclusion eventually, less of a reliance on seclusion. This amendment does not move us towards less of a reliance on seclusion. It does not move us towards a date where we all agree we're not going to use seclusion from here on out. And so knowing that the law as it was written in 2022, adopted in 2023, gave the runway to 2024 to ban birth through 3. It would be, and I've heard multiple times, we want a runway with support. I've heard that from the school folks, and I understand where that's coming from. It's necessary. MDE has stated that we need to stick with the deadline of September 1st, 2026 to eliminate all seclusion K through 12. It would be at least part of a conversation of if we were going to adopt some sort of additional protections for students to use seclusion in 1 through 12, when are we aiming to stop? What's our goal? That would be a helpful conversation to have next to this conversation. And I'm going to turn my mic off now.
And you raise a good point. I know we've had a few conversations about this and the inability, I think, to land on a time frame given that different districts come at this from different spaces. I think the draft recommendations that we just approved move us forward to start putting affirmative obligations on districts to start exploring these alternative procedures, and certainly putting the onus on the legislature to fund the ability to do that. I agree with you. I do think we need to look at the timeline here because we can't just let it hang out there in the open and say, good luck, let's go. And so I'm wondering, I've had a couple of thoughts. Number one, we recommend a deadline that all districts have to meet. It's a little bit hard for me to say that, just given that different districts are in different spots and different spaces and have different resources when it comes to that. Number two, I'd kind of like to see how, if the legislature adopts these recommendations, how they play out. Is it gaining traction? Did we do enough? Are there other needs we haven't addressed to give the districts the tools that they need to be able to eliminate seclusion? So does that mean we come back as a work group to evaluate next year? Last thing I want to do is sit on more work groups, but I will because it's important, and I'd be willing to do that. I think we need to have a thoughtful timeline in mind, but I do think we do need a timeline. Ms. Woodward.
I'm curious about just putting some options on the table for everyone to really think about between now and our next meeting. And I think when we talk about a timeline, there are many different ways to look at that, right? Like ban by this date, right? Like here's your runway, this is the date. How long is it appropriate to give districts time to plan and prep ahead of a full out ban? That's like one way to look at a timeline. Another way to look at a timeline would be something like a 50% reduction annually until we get to X threshold, if we are truly recognizing that there may be very limited uses in very, certain settings over time. Again, to address disproportionality, misuse, overuse. What is that threshold? That's kind of what we were getting at with the ARC report recommendation, right? We know that a threshold of The alternate assessment for the alternate Minnesota assessment is 1%. Like that we know. So we strive for that. If we're over, under, at, different action is warranted. So I'm curious how this lands of it, you know, option A is to look at a timeline where it's done after this date. Option 2 is to look at a timeline when there's a threshold we're striving for that feels reasonable and appropriate and would indicate that the safeguards are working, the restrictiveness of the settings it's permitted are working, et cetera. Because from a school perspective, being able to strive for reduced use, which is what we want, eliminating the need, that's what we're working toward, feels better than that outright just, here's the timeline when the ban takes effect.
That language reminds me of the language in my child's IEP. Because, yeah, it doesn't say, his IEP didn't say you will stop engaging in injurious behaviors by the time you reach grade 5. It was not that. That was setting him up for failure. It was, we will see a 20% reduction in injurious behaviors. We will see Cullen engaging in non-preferred tasks 3 times out of 5. Attainable goals, attainable measurable goals. I like that idea because it gives each district the time and space to do what they need to do to reach the ultimate goal, which is to reduce and eliminate the use of seclusion. I'd be interested in hearing other thoughts. Mr. Haviland.
Thank you, Chair Seeberger. I would agree with that sentiment because I think as we work our way through the second full year of UCARO implementation as a district, that I feel like we're doing a pretty good job of rolling this out. We're still having growing pains. I mean, we have some buildings that are knocking out of the park and other buildings where we have some drift or some staff that aren't quite sure if they're buying into this yet. And UCARO, for example, does take a certain level of coordination and physical ability to implement, and sometimes those incidents that you're working through can last for a really significant amount of time compared to like a CPI move or a PCM move. And so as we're working through that, I just want to say we need a runway to be able to work our way down. And I'm just going to piggyback what Nicole and what you said earlier too, like what are our solutions if we don't have this as a tool as we're still moving forward? Like how do we address staff who have questions about this, because it is our smallest humans that are causing our biggest injuries with our staff right now and have been for quite some time. And so I want to be able to turn to them and say, like, here is our plan. And I think just a straight up elimination of seclusion doesn't provide them with that sort of assurance that we are caring for them and have a thoughtful process as we're moving forward. I think we have to consider like if they are facing you, all of us as on the work group, if we want to keep these people in the field working with these students every day, dealing with emergency situations that come up every day, even with the use of UCARO as a tool, what is going to be our solution when these emergency situations continue to pop up, as they will?
Ms. Chose.
Thank you, Senator Seeberger. From a NAMI Minnesota perspective, I think we've been pretty clear, and I've been listening carefully to, I think, both sides of the issues here. As an organization, as NAMI National, as NAMI Minnesota, we don't want to see seclusion, right? And I think we've all said we agree with that. It's how we get there. That's a question, whether we just cut off or there's a runway. In our recommendation, there was a runway. And I think we still just believe that, and I agree with what you said, Ms. Heiser, that we need some kind of timeline or goals or intent, and that's absent in what we're looking at right now, to get there. So, you know, in our recommendations and NAMI Minnesota's recommendations, we were very clear about we're doing this with the intent of ending seclusion, and that language isn't anywhere either with intent. And so, you're right, as written, we would just continue with where we are. So I think the question again comes down to that timeline or how we do that. For us, I think that makes sense. We certainly understand all of the issues and understand the trauma and want to get rid of seclusion for sure. And also understand the issue of funding and training and the realistic challenges that educators are facing in this runway. Thank you.
Ms. Sandsmark.
Thank you, Madam Chair. And I really appreciate Dave and all the other administrators on this work group that are bringing in, teacher perspective. And as a former teacher and as someone that did work in setting 4s and 3s and was assaulted at a few different times, I understand needing something in place. I think there's just no way for my work and as a representative of so many folks in my coalition to be able to be okay with rolling, I know we don't love the term rolling back, but undoing the current pre-K or birth through 3 ban. And also as someone that has been hurt before by a child that was dysregulated, didn't trust me in that moment. I understand the fear when you aren't getting through to a child and you just are trying to figure out the way to get through. To me in that moment, what was needed were supports and not removing the child into a space by themselves. I was in need of a partner that I could be working with to help de-escalate the situation. I won't, give any more specifics on the individual and where I was and all that stuff. I don't want to respect that child, hopefully really successful now current career, but in my bones, I see that there are gaps. I see that there is need for more staff support. I just feel like the conversation should be about what are the things that we bring in as alternatives with a timeline of, okay, we can't do that right now, but what does that look like in 4 years, 2 years, now? What does that look like? Because I don't have a perfect way to surmise this and a perfect way to put a bow on it, but it just feels, it would have felt wrong in that moment as I can feel it in my body still. I never would have wanted to put this child in a room by themselves. What I wanted was another person in the room or the ability to have more staff and have more funding for more individuals there to help work with that child. What I experienced was being in a one-on-one situation with honestly not the training I needed. I was not in a situation that I would ask anybody to be in. And I think what we've talked about as better recommendations for training, all the stuff that we're talking about, better mental health supports, it feels like at the crux of the issue is a systems problem and lack of people, lack of humans, lack of training that just needs to be corrected. I know schools are doing as much as they can right now and are doing the best that they can. So it sounds like to me, we just need to continue to do more. And I think there's good recommendations out of this work group, important adjustments to the idea of the IEP process and all these things. But I just don't see, I just want to put a fine point that our coalition and how I'm able to vote on this, I won't be able to agree to any changes to a current ban and but need assurances that we can look towards a long-term K through 12 full ban as per MDE's recommendations in other states in this country that have made this step. So it's long-winded. I just wanted to share that experience, but and the perspective I'm coming from on that. So I understand the teacher perspective, and I can feel it in my body and understand the fear. It just shows me that we aren't doing enough then. So what are the things that we need to do? So I'm gonna leave it there.
Thank you, Ms. Sandsmark. I hope you're okay emotionally. It's hard. It's hard. And again, I mean, not every student, seclusion is not right for every student, and it certainly wasn't in the student in your case. And I want to clarify that even under my amendment, seclusion remains banned. There's just an exception to allow it with the consent to the parent. So the presumption is it's a ban. If you look the way it's written, it's prohibited. It's a prohibition from lines 5.1 at 5.13. The following acts or procedures are prohibited. And it says the use of seclusion on children from grade 1 through grade 6, unless, and that is the carve out. So it's still banned. But what it's doing is it's providing additional protections for the staff. It is allowing access to a tool that is not appropriate in every instance, but is appropriate in some instances. And I want to again remind the work group that my son was also subject to law enforcement action because of his because he was unable to regulate himself at times. When he was at Valley Crossing, we know that the Woodbury police carry black handcuffs because they were called to restrain him. We know that Hudson police do not. Theirs are silver. We know the color of the handcuffs of most of the police forces because of his interaction with law enforcement. When he was at Bel Air as a 5th grader, the school resource officer arrested him and brought him to juvenile detention on a Friday and charged him with 2 felonies. I don't think we want that for our students either. If we take away seclusion, a place for everybody to be safe and students to de-escalate, my fear is we are opening the door to law enforcement. I'm not saying any of my colleagues or my friends here on the left of my desk here would do that. My concern is schools that don't have the resources, training, ability, and knowledge to appropriately deal with their students. The last thing I want for anybody is to go through what my family went through, having an 11-year-old boy arrested, brought to Ramsey County Juvenile Detention. I've shared this story. The only reason he got out that night on Friday was because they needed the space for another kid that was coming in. We had an arraignment on Monday. My husband was gone for the Navy. He had to do an emergency leave to fly home. We retained an attorney over the weekend. Over the weekend, the SRO amended his statement to make it sound worse. And at the arraignment on Monday, the state recommended remand for my son. They wanted to put him back in jail. We were within that juvenile justice system for 1.5 years. Part of his being free was no same or similar situations. Let me ask my friends here, if you tell a student who gets dysregulated easily, just don't do that anymore, does that work? It doesn't work that great. So we were living under the threat of my son being brought back to juvenile detention because of his inability to regulate himself. That meant that we had to hit pause on all the behavioral therapies because a lot of times things get worse before they get better. We had to give in and give him his way every time because we couldn't afford to risk having law enforcement come in again have him violate the terms of his release, and go back to jail. That is a horrible thing to go through when your son is 11, or any age. But I think 11 is pretty little. I'm going to share this. At one of our last court hearings, I think it was the one where he had successfully completed probation, and we went in and the judge dismissed the charges, and we went out to eat. I wish I had this photo. He was 11 years old. He was a little boy. He wasn't that big man that you saw the other day. He was wearing a button-up shirt and a tie. And we went out to eat afterwards. And he reached in his shirt like this, and he pulled out his blankie. And he said, I brought blanket with me for luck. And he sat and he ate lunch with this little blankie over his shoulder. That's a child. And that's what I don't want. I don't want any more children thrown in jail because they can't regulate themselves through no fault of their own. That's why I understand in the awful stories of students subjected to seclusion, terrible. No, it's not okay. I'm not minimizing that in any way. Don't want that. But I also don't want any other student to go through what my son went through. Whether they're 10, 11, 15, 18, because we could have prevented it by offering them a hot second in seclusion to calm down. I don't know where that came from. All right, so I think we were talking about a timetable. All right, I think I started saying this was the emotional topic for me. It's hard to be a mom. Oh, that's Ms. Winship. Oh my God, I'm sorry. I knew you had something to say too. Ms. Winship.
No problem. Thank you, Senator Seeberger. Going back to the timeline, I am wondering if our timeline is around setting 3 and 4 programs, fully implementing one of the vetted alternatives to seclusion as kind of a first step. So then we know that everybody has some additional tools, and then from there, continuing to move forward. Just a thought that I had.
Any thoughts? Ms. Winship, are you suggesting perhaps a date by which setting 3 and 4 programs have a vetted program implemented?
Yeah, I mean, that's kind of what I was thinking. I can't say it's a totally thought out thought either, but yeah, that's kind of along the lines of what I was thinking. Because as we've discussed, setting the timeline for ending seclusion is trickier said than done. So as kind of an in-between. And of course, this goes along with the funding included. We're not expecting districts to meet a timeline deadline without the funding.
Ms. Woodward.
I'm not answering your question, Ms. Winship, not unintentionally. I'm processing that. Committing to implementation timelines, it's one thing that I'm trying to be really thoughtful around. I guess my essential question to those sitting at the table who have the desire for the ban, and if the goal was around a threshold, setting a threshold for use, I'm thinking about the cases where a district receives a student who has such a high level of dangerous behavior. I'm talking about the kids for whom we're currently wearing like Kevlar clothing. and shields and things like, I mean, there's some pretty serious stuff that particularly in a setting 4 that our staff are facing. I just want an answer, I guess, to that question, because that might be something, again, between meetings that we could think through and have people who do smart statistic things with data help us get to. Is there openness to that type of a timeline, that instead of outright, by this date, this ban, like we're striving for an annual reduction in rate of use and then an ultimate like threshold that feels appropriate given this balance of safety we're trying to achieve? Like, is there any openness to talking further about that type of timetable that involves goal targets for reduction in use and then a threshold eventually that feels very limited? Curious.
Ms. Heiser?
Yes, if there is a threshold of 0 eventually, and there is a date upon which that hits. So for example, I'm going to have to disagree with the premise that this amendment is a ban. It's not. There's a colon instead of a period here. If we wanted to say the use of seclusion from birth through grade 12 is banned on September 1st, 2028, period, until that time, these are the things that are going to be put into place to add additional parental protections, and we are going to slowly decrease these thresholds this year and next year and the next year, getting up to that eventual date. We could talk about that. I think I'm speaking on behalf of Disability Law Center. I'm not speaking on behalf of anybody else.
Ms. Sandsberg?
Thank you, Madam Chair. As far as solutions, not suspensions, as a coalition, which is broad and moves and grooves in different modalities, I wouldn't be able to say definitively that we would be able to agree or be 100% in on that. I'm not saying that I'm not interested in the discussion, but because I'm in representation of a lot of different individuals, it would be something that we'd have to discuss as a coalition and come to a consensus on about that specific recommendation. So I like the idea of having clarity on that and setting that up, but that's something I would need to talk to my people about and make sure that the orgs and individuals I work with feel comfortable with that.
All right. Sounds like we still have some work to do. Talking about a timeline, I think all of us agree there should be a timeline. We just haven't quite landed on what that's going to look like. I do like I do think setting goals is important. I think it gives districts and schools something to work toward, and it gives us some way to measure where we're going and what headway we're making. I like the notion of putting a goal in place for all districts to have a vetted alternative in place. I like the notion of gathering data and holding districts accountable to movement in the use of seclusion. I'm not sure how I feel about a date when all seclusion in the state of Minnesota will end. I think that puts school districts in a difficult place. I think there's a way we can do it, but I'd like us to think about it a little more. What I'm going to do, we have one more meeting on the books. It's in 2 weeks. I'm going to schedule another meeting for next week so we can work through some of these issues. I will have Mr. George reach out and get availability. Can you do that? I'll let Mr. George do that and come up with a date. If it needs to be virtual, we'll do it virtual, however we can do it so that we can continue this discussion and hopefully come up with some parameters. Maybe we can't reach agreement on this, but I would like us to flesh it out a little more. We've done, I think, some really, really good work here. I think there's a way we can do it. So, any other comments by folks? We're almost at 4 o'clock. All right, with the few minutes that we have remaining, and I'll have Mr. George do that, he'll follow up with you guys. I would just like to have Mr. George walk through the revised draft report that he's put forward. There are a few minor changes, clarifying technical changes, and edits in response to comments of members. Mr. George.
Madam Chair, thank you. Members, thank you for those that submitted feedback. I've included essentially all of it. Let's see. On pages 9 and 10, I've added data on disproportionality. On pages 12 and 13, I've added a fair amount of parent and staff testimony. Let's see. On page 14 and page 15, I've added some context for findings of violation of the seclusions in violation of the restricted procedure statute, just some added context into what those violations look like in the MDE's decision letters that we received. As well as, on page 16, as well as some additional comments on disproportionality that was discussed in the work group. I think, Madam Chair, members, those are the, and then page 21, starting to summarize the process for recommendations, recommendation development that we've been doing December through now. And then, obviously, at the next meeting, we'll be adding recommendations that were approved, and then the further process that's ongoing right now. Madam Chair, members, I can answer any questions on these updates.
Any questions or comments? All right. Look for a communication from Mr. George here in the next couple of days, and we will then set our next meeting of the work group, where we will try to hammer out some of these issues where we're not quite all on the same page. All right, with, is that it? Nothing else? Okay. With that being no further business before this work group, we are adjourned.